jump into the 1960s and 70s. And it was in this complicated and charged arena of reproductive and sexual politics that the American judiciary really elaborated what we think of as a right to personal privacy. And this development has understandably been celebrated for significantly expanding freedom, particularly the freedom of heterosexual women and gays and lesbians. But it's important to remember, so here's some cases I'm going to talk about. There's not going to be a test, so. But I thought it would be helpful to have some of these cases listed for you. It's important to remember that in the same era that the courts are elaborating this right to privacy, we have a broad and diverse feminist movement and an eclectic gay liberation movement. And both of these movements develop very robust visions of bodily integrity, sexual liberation, and reproductive freedom as keys to full citizenship and equality. The gay liberation movement rejected heteronormativity and the legal and social structures that sustained it. Feminists demanded access to contraception, abortion, and woman-centered health care, along with freedom from coercive sterilization and sexual violence. And the right to privacy, while it expanded freedom, proved an inadequate tool for realizing these expansive visions of freedom. So today I'm going to give a very brief overview of the development of a right to privacy in reproductive and sexual matters, and then I'll speak briefly to some of the limits to grounding sexual and reproductive rights within the concept of privacy. So first, the development of the constitutional right to privacy. You won't find privacy listed in the Constitution as a right, as Ben suggests. Liberty, yes, and so that's where we get this elaboration. Beginning in the late 19th century, we can trace a gradual and halting elaboration of such a right, grounded in various other constitutional principles. So there are arguments about the First Amendment, the Third and Fourth Amendments, but most importantly, the Fifth and 14th Amendments' guarantee of due process is where the courts really locate that right to privacy. The government, the federal government or the state government, cannot deprive persons of life, liberty, or property without due process. And over time, the Supreme Court began to suggest that that liberty that a person cannot be deprived of, or the right to be let alone, free of government intrusion, included personal decisions related to family, to procreation, to child rearing. So let me mention a couple milestones along this journey. 1923, Meyer v. Nebraska, in which the court struck down Nebraska's law prohibiting instruction in any language but English in both public and private schools. Pierce v. Society of Sisters, 1925, the court struck down Oregon's law mandating public school attendance, so sort of outlying private schools essentially. And a court majority agreed in both of these cases that liberty under the Due Process Clause of the 14th Amendment included certain rights that were not explicitly listed in the Constitution. And this is a quote, rights long recognized at common law as essential to the orderly pursuit of happiness by free men, and which in the cases at hand included the right to rear one's children, educate one's children as one saw fit. So the court begins to carve off this domain of child rearing and family life as something that ought to be private, free of government interference. Skipping ahead to 1942, Skinner v. Oklahoma. In this case, the court struck down Oklahoma's law that mandated sterilization of individuals who were more than twice convicted of crimes of moral turpitude. And here the court defined marriage and procreation as constitutionally protected private matters. In fact, Justice Douglas actually called marriage and procreation basic civil rights of man. That issue of marriage as a basic civil right is another conversation we could have if we had time, but we're going to stick with privacy here. What's interesting, though, is such rulings didn't actually really alter the basic terrain on which women struggled to gain control of their reproductive lives, or in which lesbians and gay men sought to become full citizens openly and without fear. So to give you a sense of this, if you put yourself back in the early 1960s, most states in the early 1960s strictly regulated or prohibited the purchase, sale, distribution, and use of contraception. State laws prohibited virtually any form of abortion, which led hundreds of thousands of women every year to become criminals by seeking extra-legal terminations. Dozens of states coerced women into sterilization procedures, mostly poor women of color who depended on public hospitals. The practice was common enough in the South, practiced on African American women, to earn the nickname Mississippi appendectomy. In almost all states, sodomy laws prohibited same-sex sexual activity, essentially criminalizing lesbians and gay men and justifying widespread discrimination against them. So this is the world, a world that we don't think of as a world where privacy is protected, right? Personal privacy is protected. In the 1960s, change really began, and it began in the arena of reproduction. Social movement pressures, changing gender and sexual norms, and activist litigators pushed the court to limit state interference in matters of procreation and sexuality by broadly expanding an incipient privacy doctrine under the rubric of substantive due process, that 14th Amendment right to due process. So 1963 is a real a revolutionary moment here, Griswold v. Connecticut. This had to do with Connecticut's law that it was a very restrictive birth control law. It prohibited doctors from advising married couples on contraception, and it prohibited married couples from using contraception. And in 1963, the Supreme Court struck down that law, arguing that it was a violation of the right of privacy grounded in the 14th Amendment's guarantee of due process, as well as the 9th Amendment's provision that unenumerated rights were retained by the people. The court majority, interestingly, in Griswold v. Connecticut, relied very heavily on the concept of marital privacy. So here the court's locating privacy within marriage. It conjured images of police searching, quote, the sacred precincts of marital bedrooms. An idea, quote, repulsive to the notions of privacy surrounding the marriage relationship. So the court found that marriage was a relationship lying within a constitutionally protected zone of privacy. But the court then, not too long after, moves beyond marriage in terms of privacy. In 1972, Eisenstadt v. Baird, the court extended the right to birth control to single individuals. Now, it did so on equal protection grounds. So if married couples have a right to birth control, then single individuals have a right to birth control. But Justice Brennan's opinion extended the notion of privacy beyond marriage to procreation writ large. If the right of privacy means anything, he wrote, it is the right of the individual, married or single, to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. So privacy now, after Eisenstadt v. Baird, is privacy in terms of reproduction is a constitutional right possessed by individuals. The court's acknowledgement of this right to privacy in procreation offered a legal opening for an emerging reproductive rights movement that was seeking to decriminalize abortion. That movement had been going on since the late 1960s in a political way, working to reform or repeal restrictive state laws, and it had some success in doing so, but had also run into the emergence of a very powerful right to life movement that was stalling these legislative efforts. So the courts, newly committed here to reproductive privacy, seemed a more promising route for overturning those laws. And sure enough, in 1973, I'm sure you all know, Roe v. Wade, as well as Doe v. Bolton, a court majority struck down restrictive abortion laws in Texas and Georgia, and thereby many other places, because they, quote, invaded the plaintiff's right of privacy and liberty in matters related to family, marriage, and sex, and deprived her of the right to choose whether to bear children. That's from the Doe decision. Thus, quote, the right of personal privacy includes the abortion decision. So this is the revolution, right? Reproductive privacy. But the court in Roe v. Wade doesn't actually affirm a right to abortion. And in fact, it circumscribed a pregnant woman's right to privacy in significant ways, arguing that because she contains an embryo, a fetus, she can't have absolute right to privacy here. Most importantly, the court in Roe declared that there was a state interest in maternal health and in fetal life that could override a pregnant woman's right to privacy after the first trimester. And subsequently, an increasingly conservative court opened the way to significant state restrictions on abortion in 1989 and 1992 in Webster and Casey. Henceforth, any restriction that could be defended as serving a rational state interest and that did not prove an undue burden would trump a pregnant woman's right to reproductive privacy. For feminists, the privacy argument had been a compromise anyway. Some feminist attorneys and women's rights advocates in the 1960s and 70s advanced a different constitutional argument. A woman's right to control her body was a foundation of basic sexual and economic equality with men. Therefore, denial of that right was a denial of her 14th Amendment right to equal protection rather than due process. But the equal protection argument was not constitutionally available until the mid-1970s. The Supreme Court had not yet identified women as a suspect or protected class under equal protection clause. And by the time the court did apply equal protection to sex, the judicial logic of privacy was entrenched and the court was moving in a conservative direction anyway. So we're left with privacy. And privacy is a classic negative right? Freedom from interference. It's a much less robust grounding for women's reproductive freedom, and one with some inherent problems, as many scholars have pointed out. And there's a lot of criticism on this, and I'll just mention a couple problems. And the first is access. One legal scholar puts it this way: what the court created in Roe is not a right to legal abortion. It is a negative right against the criminalization of abortion in some circumstances. That no more creates a genuine right to a legal abortion than Brown created a right to an integrated school. Abortion opponents quickly capitalized on this limitation with the Hyde Amendment, which was an amendment to appropriations bill, first passed in 1976 by Congress and passed every year subsequently. And this amendment barred Medicaid funding for abortion, and at the time it passed, about a third of all abortions were paid for under Medicaid. A majority of states followed suit and prohibited the use of state funds for abortions. The Supreme Court confirmed in 1980 in Harris v. McRae, yeah, that's up there, that federal and state governments had no constitutional duty to fund abortions. Hewing to the logic of privacy, the court majority concluded that a woman's freedom of reproductive choice, grounded in privacy, did not carry with it, quote, a constitutional entitlement to the financial resources to avail herself of the full range of protected choices. When some of President Jimmy Carter's female staffers complained to him and asked him to come out against the Hyde Amendment because it created an unfairness, right? Middle class and wealthy women could access this right and poor women couldn't. Carter responded that life is not fair. The court has taken a similar stance in this and other arenas, repeatedly holding that financial need does not identify a suspect class under equal protection. This leaves poor women at the mercy of the market. Abortion becomes a health care service that women with means can purchase. But even for women with means, the lack of an affirmative right to abortion, which an equal protection grounding would have secured, but a privacy grounding doesn't, has meant eroding access. Just witness the hundreds of restrictions imposed in the last 3 years by state legislatures, including mandatory waiting periods, requirements making it impossible for clinics to operate, parental consent, notification laws, mandatory ultrasounds, etc. A second and related problem with the privacy rationale is what scholars call legitimation costs. In short, the language of privacy and the accompanying rhetoric of choice, some scholars suggest, defines reproduction and parenting as individual consumer choices, thereby legitimating a lack of public support for caregiving. So the contraction of social welfare and income support for single mothers, lack of publicly funded childcare, and mandatory paid family leave all seem reasonable when the decision to bear children is framed in terms of individual choice. So one other important, well, there's many other important arenas, but I want to talk about sexuality. It took the courts much longer, until 2003, to extend the right to privacy to consensual same-sex sexual activity. The doctrine of substantive due process in matters of private sexual behavior was well established in the rulings I've just discussed, but at least twice, in 1976 and 1986, the court upheld state sodomy laws, therefore refusing to extend the right to privacy to same-sex sexual activity. In the latter case, Justice Blackmun offered a dissent. He said, "The right of an individual to conduct intimate relationships in the privacy of his or her own home is the heart of the Constitution's protection of privacy." A court majority finally agreed in 2003, finding that Texas's sodomy law, and by extension those in, I think, 13 other states that still outlawed same-sex sexual activity, violated the plaintiff's right to privacy. But the Lawrence decision, Lawrence v. Texas, didn't have much of a spillover effect. It didn't become a foundation for overturning other discriminatory laws or treatment against gays and lesbians. And this is because, as in reproductive rights, it relied on a negative right of privacy. When John Lawrence and Tyrone Garner challenged Texas's sodomy law, they charged that it was a violation of both privacy and equal protection. And the Court of Appeals of Texas agreed on both counts. Not only did the statute prove a violation of their privacy, but it violated Texas's Equal Rights Amendment by criminalizing conduct based on the sex of the participants. But the Supreme Court explicitly declined to invalidate the statute on equal protection grounds. The court majority, in fact, explicitly qualified its ruling, noting that the case, quote, "does not involve whether the government must give formal recognition to any relationship that homosexual persons seek to enter." So Lawrence, rooted in sexual privacy, does not offer the basis for challenging other discriminatory treatment against gays and lesbians. So in conclusion, the elaboration of a constitutional right to privacy in sexual and reproductive matters certainly expanded the rights and freedom of women and gay men, but as a negative right, the right to be free from governmental intrusion, it certainly has limits.